All right. Now we're going to move on to the other categories we looked at before. There have been several termination of parental rights cases of interest this year, including 2 out of the Tennessee Supreme Court. So let's move to termination cases.
You are terminated.
All right, our first case is a Supreme Court case where they clarify the standard of review in termination cases. After these parties get divorced, mom tries to kill father. While claiming to give him a friendly flu shot, she actually injects him with drugs used to euthanize animals. And as a result, she's convicted of attempted second-degree murder and sentenced to 12 years at 30%, which means she'll be eligible for release after 4 years. The children are 7 and 5 at the time of the sentencing. After this conviction, though, Dad, who's feeling a little more charitable than perhaps I would have, agrees to amend the parenting plan to provide for the gradual return to the original schedule when Mom is released from prison. But years later, he marries stepmother, and then father and stepmother petition to terminate Mom's parental rights and proceed with a step-parent adoption. The trial court says while this 12-year sentence, while the children are under 8, that constitutes grounds, there's no proof here that mother poses a danger to the children. Yes, she posed a danger to Dad, but not to the children. And the court says this case is so close, but father and stepmother failed to prove that termination was in the best interest by clear and convincing evidence. The Court of Appeals reversed the trial court and said, no, the record does contain enough proof, and so Mom's parental rights were terminated. On the substantive question, the Supreme Court took it and said none of the best interest factors support termination of Mom's parental rights, so the Court of Appeals is reversed and her rights are restored. What's interesting about the case, though, is there had been confusion. The Court of Appeals has used various standards of review in appealing termination cases. And the court said, well, we're going to use this opportunity to clarify what the standard of review is. So that's what they say, is that findings of fact are reviewed de novo with a presumption of correctness unless the evidence preponderates otherwise. Once the findings are reviewed, the court has to determine whether that constitutes clear and convincing evidence that termination is in a child's best interest. So the case is also worth noting because both the trial court and the Supreme Court commented on the lack of expert proof at trial on the issue of the predicted psychological effect to the kids of the resumption of visitation with Mom. While Dad was arguing that that was going to be a problem, he didn't present any expert proof on the point, and so both the trial court and the Supreme Court said, hey, Dad, that would have been really helpful in furtherance of your argument. Now here's a Supreme Court case clarifying the issue, an issue on the grounds of abandonment of what is token child support. Here, when these folks get divorced, Dad is ordered to pay child support of $2,500 a month. But later, his visitation gets suspended by the trial court, and a year after that occurs, he petitions to reinstate his visitation. But after he files that petition, he does nothing at all to prosecute his petition for several years. Mom ends up getting remarried, and mother and stepfather then move to terminate his parental rights and proceed with a step-parent adoption. At the time they filed that termination action, father had had no contact with these kids for 3 years. But in the 4 months that led up to the filing of the petition, he'd only paid $3,500 of the $10,000 that he owed in child support during that 4-month time. The trial court says that his failure to see the kids in the 4 months leading up was not willful because of the order that was issued suspending his visitation. The trial court also said $3,500, even though you owed $3,500 is not token support. Now we all know if you deal with these cases, token support, we're usually talking about $5, something really, some just negligible amount. So the trial court says $3,500 is not token support, even though he owed $10,000 for that 4-month period. So the court concludes there are no grounds here and Mom's petition is dismissed. Well, the Court of Appeals reverses, and on the issue of the failure to visit, they say that it is willful and it does constitute grounds because Dad did nothing to prosecute his petition to have his visitation reinstated for 3 whole years. So his failure to act on that constituted abandonment. They were united on that. On the issue of token support, though, the court was split 2-1. The majority said that paying 35% of your obligation is token support in this case. Token support is defined in the statute as that support that is insignificant given a parent's means. Well, here the proof showed that father was a physician. He earned over $120,000 a year. He had $500,000 in property that had no debt on it at all. And the opinion notes at the time he was building a home that included a $40,000 fireplace. So they say, under those circumstances, paying $3,500 when you owe $10 is token support. The dissenting opinion said there was no intention to abandon in this case. Well, the Supreme Court gets it, and on the issue of the failure to pay support, the Court of Appeals is reversed. The Supreme Court says there's really little evidence in the trial court record about dad's income and expenses during that 4-month period, and so there was not clear and convincing evidence that paying $3,500 constituted token support. On the failure to visit, the Court of Appeals was affirmed. They said Dad had no excuse for taking no action to prosecute his petition. So now that grounds exist, the case is remanded to the trial court for a hearing on best interest. But this case holds that token support, 35% of your child support obligation is not token support for this father. Well, there's another case that came along shortly thereafter that dealt with the same issue. Here we have never married parents of 2 kids. Father's awarded visitation and pays child support of $120 a week. He eventually just stops exercising his visitation altogether. Mom marries stepfather. He petitions to terminate and proceed with a step-parent adoption. Trial court says we have grounds here, the failure to visit, and that in the 4 months leading up to the filing, Dad only paid 30% of the child support that he owed. So after finding that the termination was in the child's best interest, Dad's rights were terminated. The Court of Appeals says the failure to visit here is not willful by clear and convincing evidence. The proof showed that Dad didn't have Mom's contact info, her new address, and so forth. He didn't know where she lived. But they did make arrangements in the 2 months that leading up to the filing for them to meet on twice, he said, but Mother never showed up, and Mom didn't refute that testimony. So the court says Mom didn't promote visitation here, so the proof just wasn't clear and convincing that his failure to see the kids constituted grounds. But on the issue of token support, the court looks to the previous case we just looked at, the In re Angela E case, for guidance. And here they conclude that the payments he made, in other words 30%, were not insignificant given his means. And so therefore there was no token support. So the order terminating his parental rights was reversed. Now, compare the father in the case we just looked at, the Angela E case, with the dad here. In that case, you've got a physician, he's got lots of money, his income is good, he's got lots of property, and he pays 35%. The court says that's not token support. That's not insignificant given his means. Here, this dad's a truck driver, earns about $600 a week, and he's paying 30%, and they again say that's not token support. So although you have very different situations, we have the same result. Paying roughly 1/3 of your support in both scenarios is not considered token support. Here's a case that deals with an issue of token visitation. Here we have Mom and Dad are married, but Dad lives in Massachusetts, Mom's in Tennessee. Aside from 1 month when Mom lived in Massachusetts with Father, the child had always resided in Tennessee. The kid's only 2 years old when the parties get divorced, and Dad is awarded supervised visitation. That put him at the mercy of Mom's schedule. Because he's so far away, he's got to arrange with her when he can come in and see the child. Well, Mom ends up marrying stepfather, and when the child is 13 years old, so now we're fast forwarding 11 years, when the child's 13, Mom and stepfather petition to terminate Dad's parental rights and proceed with a step-parent adoption. The proof showed that the father visited the child in Tennessee roughly about 1 time a year, including the month prior to this petition being filed. He came in for a couple hours on Saturday, saw the kid for a couple hours on Sunday, and that's it. That's our contact for the year. We'll see you next year. Mom said this is token visitation that constitutes abandonment and that provides grounds. Dad said, well, Mom makes it really difficult for me to come visit and communicate with the child. And the child actually testified, this 13-year-old child said, I'm not comfortable around Dad and I want stepdad to adopt me. Well, the trial court comments that, Dad, you have done nothing to show that you are a father. It is in this child's best interest to have your rights terminated. However, no grounds exist because you did exercise your parenting time in the 4 months that led up to this filing. So therefore, termination was denied. Mother appealed. You might wonder what would have happened if Mother had waited a few more months and filed then once she had no contact in that 4-month period. But those aren't our facts here. The Court of Appeals looks at the law that says token visitation is visitation that's so infrequent or short as to merely establish minimal or insubstantial contact with the child. That determination requires a very fact-intensive inquiry. Here, the dad lived over 1,000 miles away. He worked a factory job for an hourly wage, and the proof showed that mom was not real cooperative with his efforts to come down and see the child and communicate with the child. So the court says, under these circumstances, this is not token visitation by clear and convincing evidence. Coming in once a year and seeing your kid for a couple hours is not token visitation. They also note that here, by the time this opinion's issued, the kid is 15 years old, and the court says, look, in 3 years, this child can determine what kind of relationship he wants to have with dad, if any. And our decision to not terminate dad's parental rights is not going to affect the child's relationship with stepdad at all. So there's no reason that they see to cut father out of child's life, and so the dismissal of mother's petition here was affirmed. We have some new legislation real quick dealing with grounds for termination this year. We have a case the amendment to Section G10 that provides grounds now for terminating the parental rights of someone who's convicted of rape, aggravated rape, or rape of a child where that rape results in the birth of a child. So in other words, a convicted rapist's parental rights to the child born of the rape can now be terminated. Interestingly, it doesn't mention statutory rape. So evidently that, for some reason, that's an exception to grounds. We also have an amendment adding Section G12 that provides grounds when a parent is convicted of trafficking for a commercial sex act. That's defined as sexually explicit conduct obtained by coercion or deception. And trafficking means benefiting from someone else's provision of such an act. So I think what they're trying to say essentially is like someone who's a pimp or someone who's engaged in human trafficking for sex, that if you get convicted of that, that's now grounds for termination. All right, that's it for termination. Let's move on to a few child support cases.
Child support.
Hey, we're in Nashville. That seems to fit. Okay, this is an interesting case about when an adult child can seek child support for himself. Here we have these parties are married. During this marriage, wife has an affair and gives birth to child. The husband never knew about the affair, and he thought he was the biological father of this kid. He signs the birth certificate and raises the child as his own son. Wife and husband later get divorced, and husband's ordered to pay child support for his son. Well, after this child turns 18, mom lets him know, hey, your real dad is this other guy. And the child, who's now 18, files a parentage action against the guy that mom said is your actual father. And in that action, he sought child support retroactive back to his birth, plus attorney's fees. So, hey, total stranger, I want 18 years of child support and my attorney's fees, not payable to mom, payable to me. The court ordered a DNA test which confirmed parentage. So now we have the biological parent is established. Trial court says this parentage statute references the payment of child support to a parent or custodian, and it concludes that in the absence of express authorization in the statute, that the trial court lacks the authority to award retroactive support to the adult child. The child appealed and argued on appeal correctly that once paternity is established, the paternity statute requires the court to set child support. And the father argues correctly on appeal, well, maybe so, but the right to child support vests in the parent or the person who bears the cost of raising the child. It doesn't vest in the child himself. So they're both right. Well, how do we reconcile those two arguments? The court says the parentage statute provides that when you file a complaint for parentage, it can be filed by a child if the child has reached the age of majority. So you can be 60 years old, I presume, ostensibly, and file an action to determine your parentage. But once parentage is established, that statute also says the court shall determine and set child support. So here the Court of Appeals concludes that the lack of an express provision for the payment of child support to an adult child does not nullify this statutory mandate. They say we are required to enforce this mandate because of the use of the word shall. Therefore, the holding is that an adult child may recover retroactive child support under the parentage statute. Yeah, that photo. The child support guidelines, though, the court points out, does allow for a deviation based on the equities, and so it says, trial court, you may want to consider the fact that this is an adult child. That may affect the weighing of the equities in this case. But this adult child is now required, the court says, we have to set some child support and make it retroactive to birth. Now compare this case with the Lichtenwalter case. It was just a normal child support case. It didn't involve any parentage issues. In that case, the court held that child support is paid to the parent. Even though it's intended to benefit the child, the parent's entitled to support. And the current age of the child does not change who child support should be paid to. In that case, you had an over 18-year-old child, but there was an arrearage. And so the child says, hey, I want that arrearage, come to me now. I might be 20 years old, but that's support for me, and I could really use it. And the court said that if the arrearage exists, the right to recover it vests in the parent, not in the child. So, reading these two cases together, basically the rule now is, not to make it any more confusing, the rule is that an adult child's right to recover child support is limited to parentage actions. Okay? So in a normal child support case, you can't get it, but if it's a parentage case, you sure as heck can. One thing that's, I think, is interesting about this case, what about the husband? What about the guy who had paid child support all these years, and turns out, I'm not the dad, I was paying child support for someone else's kid. Well, he had the opportunity to intervene in this case, to seek contribution or reimbursement or something, and he declined to take that opportunity, depriving all of us of a great legal issue, unfortunately. But he did comment, and his only comment, according to the Court of Appeals, in the record was that the biological father should man up. Here's a case I think that's helpful. It talks about what limits there might be on child support services authority. You know, we all have these child support cases, and child support services is involved in them. This case, sometimes they want to try to run our case for us, and this case puts some limits on that. We have a dad who's ordered to pay child support to mom. Over the years, mother obtains various judgments against dad for arrearages, and over the years, she had received public assistance, and as a condition of doing that, had signed her child support rights over to the state. Well, at the very last hearing, she's represented by her own private lawyer, but Child Support Services has intervened and they're still involved in the case. Father doesn't show up, doesn't participate at all. The child support magistrate determines there's an arrearage with interest and enters a judgment for mother against father for $72,000. Child Support Services thinks that's wrong, and they appeal that judgment to the juvenile court judge over mother's objection. Again, it goes to the juvenile court, and again, dad does not show up or participate, but the juvenile court judge reduces that judgment from $72,000 to $27,000. And mother is very unhappy with this, and she appeals. And her argument is that Child Support Services doesn't have the authority to appeal the magistrate's order over my objection. She says only an aggrieved party can appeal, and I'm not an aggrieved party with $72,000 judgment. In fact, I'm quite happy with it. The court points out that there's a statute giving Child Support Services the right to establish, modify, or enforce child support. However, the assignment of a parent's child support rights to the state does not give Child Support Services the perpetual right to control all the actions in that case touching upon child support. Here they note that although Child Support Services claims it was acting on mother's behalf, the Court of Appeals says nothing could be further from the truth. The only person who benefited from what Child Support Services did was the father. And they say that presents a conflict of interest for Child Support Services. So they only have the authority to act on mother's behalf, and mother was not an aggrieved party. She was not aggrieved by the magistrate's order. So the case was never properly before the juvenile court judge. Juvenile court judge action is tossed. The magistrate's judgment is reinstated. Here's a case that John talked about. This is a case of first impression about what constitutes income for child support purposes. Dad petitions to modify for a variety of reasons, one of which is that mother's income doesn't include the alimony dad's paying to mom. Well, in this case, he was paying her roughly $80,000 a year in alimony. So that $80,000 a year is ending up on his side of the ledger, but not on hers when we're setting child support. And he said that doesn't make any sense. And the trial court agreed and changed the worksheet to include the income that mother received from father as alimony, and mother appealed. The Court of Appeals says the guidelines say that gross income is all income from any source, and it includes, but it is not limited to, some categories, wages, salaries, and a long list of other stuff. But the list includes alimony received from someone besides the other parent in the case before the court. The Court of Appeals says the plain language of the guidelines expressly excludes from mother's income the alimony payments received by the other party, which here is father. So the trial court was reversed. Well, I'm highly critical of this conclusion. I think it flies in the face of a whole bunch of case law in Tennessee, including a Supreme Court case that came out 3 weeks before this. The Armbrister case mentions this, that when we define all income from any source, The case law says that the language includes but not limited to is to be read expansive. It specifically, there's case law that says it means that gross income is not limited to the enumerated categories that follow. Fairness, as we all know, fairness of a child support award depends on the accurate determination of both parents' ability to support. So you're supposed to consider the financial resources available to both parents. So excluding it really makes no sense to me, especially when it's a significant resource. When it's $80,000 a year, that needs to be adjusted. But nonetheless, that's my view. I'm not the Court of Appeals. This is the only case on point right now, so you need to be aware of it. This is a case that it will be helpful to you when you are facing a claim that your client is voluntarily underemployed. Here we have both parents educated at Ivy League universities, and they both had MBA degrees from Vanderbilt. They get divorced after 7 years, have 2 kids. At their trial in 2012, Dad testifies that he lost his job in real estate back in 2008 when the economy crashed. Prior to that, he was earning about $95,000 a year. Although he's been looking for full-time work in the 3.5 years since, he hadn't been able to find anything. He did do some part-time consulting work, but despite his best efforts, his actual income is $18,000 a year. Mother presented proof from an occupational expert who said the dad's earning capacity was anywhere from $75,000 to $125,000 based on his experience and education. Well, the trial court says Dad is willfully and voluntarily underemployed, and we're going to impute income to him of $36,000 a year. Dad appeals and argues that his underemployment is not willful, it's a result of poor market conditions in his field. As we all know, that before income can be imputed, the court has to find voluntary underemployment or unemployment. The court has to consider various factors that are set out in the guidelines, including whether the change in income was voluntary or involuntary, whether the reasons for the lower paying job were reasonable or in good faith. Here, proof showed that Dad lost his job involuntarily via the layoff. So the issue was his post-layoff behavior and whether that resulted in substantially lower income. The court concluded that he had made sincere but fruitless efforts to find a job in the real estate field, and notes what there was not proof of. There was no proof that he was aware of additional jobs. There was no proof that those jobs were available to him and that he just chose not to pursue them. And so in the end, the evidence preponderates against a finding of underemployment. It was remanded to set support based on his actual income. I think the case is helpful to you. It's been helpful to me. When I take depositions, I can ask the party who has the burden of proof on voluntary underemployment, do you have any evidence that these jobs were available? Do you have any evidence? I've had a case almost exactly like this, and I just went through the list of issues this opinion mentions and got no. When I go to trial, I just presented the deposition testimony, and that was it. So I think this case is helpful. If you're defending a voluntary underemployment case, you'll want to look at it, refresh your memory, and it gives you some good questions to ask as well. All right, last, let's talk about, there's one case that deals with overpayment of child support I want to make you aware of. Years after these parties get divorced, Dad petitions to modify. After a successful appeal and then remanding it back to the trial court modifies Dad's support retroactive to the date he filed 6 years ago. That retroactive modification resulted in the finding that he had overpaid his support by $39,000. Well, the trial court, Dad says, I'd like my judgment, please. And trial court says, well, Mom does not have to repay that money because it's not economically viable for her to do so. And the trial court says, Dad, I realize this unfairly harms you and it doesn't seem right, but Mom's harmed too because her child support now is drastically lower. And it tries to soothe Dad by saying, look, Dad, just relax. No one's to blame here. This is just a function of the judicial process. And not surprisingly, that didn't exactly soothe Dad. He appeals. And the Court of Appeals says, the statute here says that if a retroactive modification creates an overpayment, the obligor shall be given credit against future payments. And they note there's no authority anywhere allowing a trial court to forgive a party from reimbursing an overpayment of support. So here the trial court's failure to award a judgment to father a credit, or in this case, the child had aged out, so now a judgment to father is unjust and the trial court was reversed. It was actually remanded to the trial court to fashion an appropriate repayment schedule, which raises a question for me. Why is the trial court set a payment for repaying a payment schedule for a judgment? Why can't Dad just collect it like he would any other judgment? Also, if Dad had underpaid his support, that mandatory 12% interest would have been accruing during all that time. Well, now that he's overpaid it and he's entitled to a judgment, is he entitled to post-judgment interest at the statutory rate? What about prejudgment interest? I don't know the answer. The court doesn't deal with it, but I think you've got good arguments for that. I don't know if it's going to work in front of this trial judge that wanted to forgive a $39,000 debt, but it certainly gives you some ammunition. So it raises some interesting questions. Okay, let's move on to some property cases.
Well, we can't be too far off. So if we, It's mine, you understand? Mine! All mine! Get that in there! Down, down, down! Go, go, go! Mine, mine, mine!
Let's start with a couple cases dealing with classification. Here these parties get married in 1969. Husband owns a farm as his separate property. And throughout this 41-year marriage, wife maintained the marital home on the farm, and also she did that with laundry and cleaning and cooking, did all that, the housework, but also helped the husband with the farm chores. She drove the tractor, helped maintain the fences, even cut tobacco, just did everything that needed to be done on the farm. The proof showed that the property had increased in value $331,000 throughout the course of this 41-year marriage. Trial court says the appreciation in the value is marital property. Wife substantially contributed to its preservation and appreciation, so it's marital. Husband appealed. And the law is that an increase in the value of one's separate property during the marriage does not transmute and become marital property unless the parties substantially contributed to its appreciation or preservation. The contribution has to be real and significant, and there must be a causal link between the contribution and the resulting appreciation. When the value increases without that causal link from the spouse's contribution, the increase remains separate property and does not transmute. Here the Court of Appeals says the evidence does not show a causal link. The proof instead showed that the increase was due to real estate market forces over 41 years. That's what they're going to put it on. They say there was no proof that the appreciation resulted from the efforts of either husband or wife. So the trial court was reversed, and that $331,000 of appreciation was classified as husband's separate property. I think this case can be very helpful to you if you are representing the owner of separate property and trying to argue against the transmutation of the marital appreciation, because this was a very long marriage, 41 years. We don't normally see a transmutation argument win in that scenario, where wife clearly made contributions to the preservation of that property. I mean, she kept up the house, she was working in the fields, maintaining the fences and so forth. She, over 41 years, I would think this appeal would be a long shot, but this case can be helpful to you if you're arguing against transmutation. Here's another classification case I need to bring to your attention. It's a little dry, but it's something you need to know if you do this kind of work. During this marriage, wife's father gave her an ownership interest in the family business. The purpose of this was to lower the gift and inheritance taxes she would incur when he died. Well, some income from that business was distributed to wife, but most of the income that wife was entitled to was actually retained in the business. But whether it was distributed or retained, all of that income was charged to wife for purposes of federal income tax, and it was included on the joint tax return that she filed with husband. That created significant tax liability for them. The company didn't give her any money to pay those liabilities, so instead the parties paid the taxes with marital funds here. The trial court says that wife's interest in the business is separate property because it was a gift, and the fact that she took the income she got and deposited it in a joint account, and the fact that the taxes on income that she got and income she didn't get, the taxes on both were paid with marital funds, that did not amount to substantial contribution to the appreciation of her interest in that business. So therefore, not only is the interest separate property, but the appreciation and value is also her separate property. Well, husband appealed, and the issue on appeal is the classification of that marital appreciation. Husband says, look, because the taxes were paid with marital funds, the company was allowed to retain earnings instead of distributing them to wife to pay the taxes. So by us paying the taxes jointly, this allowed this company to retain income and increase its value. There's your causal link. And the Court of Appeals agreed and said that using marital funds to pay taxes on income attributed to wife and charged to her but not distributed to her did allow that business to retain the income. That helped preserve it, helped allow it to appreciate in value, and therefore that's the causal link between the contribution and the appreciation. So here the appreciation was considered marital property. Now compare this with the Schuett case, where wife receives income from an inheritance and pays taxes on that income with marital funds. And husband tried to argue, we're paying taxes on it with marital funds, that makes it marital. Court of Appeals said no, because there's no causal connection, because you're using you're using marital funds to pay taxes on the income received from the separate property. Okay, so the holding is payment of taxes on the income received does not preserve that separate property. Well, this case, the Telfer case, is different here because the marital funds were used to pay taxes on income, pay taxes on income received and retained by the business. So in other words, income that was not distributed to the parties. So reading these two cases together, I'll try to make it as simple as I can. The holding is if you pay taxes with marital funds on income received from separate property, there's no causal connection, the appreciation is separate. If you pay taxes with marital funds on income retained by the property, there is a causal connection and the appreciation is marital property. Okay. We have a mortgage refinancing case. It seems like we have one of these every so often. Parties get divorced, wife's awarded a residence in Florida and made solely responsible for the mortgage debt. The trial court did not require her to refinance the mortgage solely into her name. Husband appealed from that and said it's error not to require her to release me from that mortgage debt within a reasonable amount of time. You know, one of the factors a trial court has to consider in its equitable division is the relative ability of each party for the future acquisition of capital assets. Well, here, husband remains indefinitely obligated on this debt and the cost of collection if wife defaults. Husband says that impairs my ability to get my own mortgage if I should want one. And the Court of Appeals says that failing to require husband to be released from that debt may be contrary to Tennessee law. You have to give a reasonable amount of time for wife to satisfy that mortgage debt either by selling the property or refinancing it to get husband's name off the debt. So here it was reversed and remanded back to the trial court to give wife, to figure out what is a reasonable time for wife to do this. This case is consistent with a case we had last year, the Dobbs case. We had the same issue, the same analysis, and the same outcome, but in Dobbs, the court gave the party 12 months. You've got 12 months, you can refinance. If you can't do it by then, you got to sell it. Pick what you want. So that may give you some guidance if you're dealing with what a reasonable time might be. Dobbs says 12 months. All right, now let's move on to some alimony.
No, you didn't do anything, Alan. I wanted to let you know that, boy, this is awkward. You remember I was dating Jake's pediatrician.
Yeah, Melnick. What about him?
Well, we started seeing each other again, and it's gotten serious.
Oh, how serious?
He asked me to marry him, and I said yes.
Oh, wow. I don't know what to say. I guess congratulations.
Thank you. I just wanted to let you know before we told Jake.
Sure. I appreciate it. It's kind of weird, isn't it? I mean, we spent so many years together. It's hard for me to think of you married to somebody else.
Yeah.
Still, I wish you the best, though.
Oh, I know you do. Thank you. Well, bye.
Bye.
Five, 6, 7, 8.
No more alimony.
All right, I want to start with a couple of cases that deal with termination of alimony. Here we've got parties divorced after 9 years of marriage. Wife's a college graduate, but she's only 33 years old. Husband is the 37-year-old major in the Army with 19 years of service. Wife wants rehabilitative alimony. She testified that her plan to rehab her earning capacity was to go to graduate school in a 3-year program. She was going to sell some real estate in the meantime to supplement her income. Trial court finds that she is the economically disadvantaged spouse relative to husband and that her plan to rehabilitate her earning capacity is reasonable. So wife's awarded $500 a month for 3.5 years of rehabilitative alimony. Now, they attempted an appeal from that, but it was remanded back to the trial court for lack of a final order, and the post-remand hearing didn't happen for 1.5 years after the first ruling came down. When that hearing happens 1.5 years later, husband says, wait a minute, wife's not using this money to go to graduate school. She said that was her plan, but she's not even in graduate school. She's just keeping that money and using it for herself. So I want it to go away. And wife admitted that she no longer intended to go to graduate school, just that her plans had changed. But despite this, the trial court refused to terminate the rehabilitative alimony. So husband appealed and argued that rehabilitative alimony is not appropriate for someone who doesn't intend to rehabilitate herself. The stated basis for the rehabilitative alimony here was wife's intention to go to graduate school, and the court said after this post-remand testimony from wife where she concedes she's no longer going to graduate school, the evidence no longer provides a basis for an award of rehabilitative alimony. It does support, however, the finding that she's economically disadvantaged relative to husband, thus an outright reversal would not be fair to her, so we're going to modify the award to make it terminate back at the post-remand hearing when husband first requested it. So she gets to keep the alimony that she got for that year and a half in the interim. So I think this case is helpful to you if you have a party who's receiving rehabilitative alimony and they're not pursuing their plan of rehabilitation that formed the basis for that award, you can use this case to terminate that alimony. Here's a termination case that gives us some guidance on what exactly cohabitation means. We've got an MDA that requires husband to pay alimony to wife for 12 years or until she dies, remarries, or cohabitates with another man. A year later, he petitions to terminate based on her cohabitation, and in fact, he just unilaterally stops paying. He says, I don't owe it, she's living with a guy. Well, wife admits that she's having a sexual relationship with a married man and that he has stayed overnight at her apartment about 2 nights a week on average. But she says we're not providing financial support for each other and we're definitely not cohabitating. The married man actually testified at the hearing and said, I have no plans to live with wife, I don't want to marry her, and even though I don't live with my wife, I don't even intend to get divorced from her. The trial court says the evidence here does not show that we have a husband and wife or partners for life type of relationship, therefore there's no cohabitation, and wife gets her judgment for the alimony arrearage. Husband appealed from that, and the court says, let's look to the dictionary definitions of cohabit, and they conclude that cohabitation requires more than just an intimate or a sexual relationship, and it requires more than just spending the night with someone on several occasions. Cohabitation requires something akin to the mutual assumption of duties and obligations that are common to a married couple or life partners. So here, the evidence supported the trial court's finding of no cohabitation and the determination, or no cohabitation, so the trial court's ruling was affirmed. Husband had to keep paying for 11 more years. Here's the same case we talked about a little while back where we had the Vanderbilt MBAs dealing with the voluntary underemployment. There were a lot of issues in that case, but there's a transitional alimony issue that I think is worth noting. Again, both have MBAs from Vanderbilt. Husband lost his job when the market crashed. His income went from $95,000 a year to $18,000, and wife earned $203,000 a year. Husband wanted transitional alimony of $6,000 a month for 4 years. The parties were separated, though, for a year and a half before this trial rolled around. Well, the trial court denied transitional alimony to husband, noting that the parties had been separated for a year and a half. The trial court said they've already gone on, you've gone on with your lives, and you've already started supporting yourselves. And in fact, husband has already transitioned from his married lifestyle to his post-divorce lifestyle. So the Court of Appeals looks at this case and affirms it, but there are two things that I think are interesting about their analysis. First, they talk about husband's earning capacity. Here, the proof showed his earning capacity was greater than his actual income. Remember, wife's proof was from an expert that said his earning capacity is anywhere from $75,000 to $125,000, but his actual income is $18,000, and he's not voluntarily underemployed, right? Well, the court says that it's okay to use earning capacity instead of actual income for the purposes of alimony, even when there's no finding that the party was voluntarily unemployed or underemployed. So they say, looking here at husband's affidavit of income and expenses, if he earned up to his minimum earning capacity of $75,000 a year, he'd have a monthly surplus of $17 whole. Therefore, he doesn't have a need for alimony. Not based on his actual earnings, even though he's not voluntarily underemployed, there's nothing more he could do to increase his actual earnings. His earning capacity means he doesn't have a need. I thought that was worth noting. He didn't prove his need. The other thing they point out is this causal relationship. They note that husband earned less than wife throughout this marriage, and he did nothing to subordinate his career for the benefit of the marriage or the family. Therefore, he didn't suffer any economic detriment as a result of the marriage. There was no causal relationship between his need for alimony and some sacrifice that he made in his career for the benefit of the marriage, so the denial of transitional alimony was affirmed. And last, our last alimony case, this is a case that I think is a cautionary tale for all family law attorneys. We have an MDA that requires husband to pay periodic alimony of $1,200 a month for 7 years. And the MDA specifically said it's periodic alimony. Well, shortly after this divorce, the wife remarries. Husband then moves to terminate his obligation, and the court notes that while the MDA didn't say anything about termination upon remarriage, husband says it's required because the MDA says this is periodic alimony. And the statute defining alimony in futuro says it's also known as periodic alimony. And it further says that alimony in futuro terminates automatically upon the remarriage or death of the recipient. So husband says it terminates automatically. The trial court agrees with husband and says wife's alimony is subject to the statutory rules for periodic alimony, even though it was for a specific period of time. So husband's alimony was terminated and wife appealed from that. Neither side was arguing that this is rehabilitative or transitional. So the issue for the court was, is this alimony in futuro or is this alimony in solito? We know that in futuro is long-term support that lacks some certainty because it can be affected by future events, so it's open-ended, but it remains modifiable by the court. Alimony in solito is also long-term, but it's characterized by a definite amount of money. It's not modifiable except by agreement, and the money is paid in a lump sum or in installments, but it does not terminate upon the death or remarriage of the recipient. So the court has to figure out which of these is it, and here the determining factor is the definiteness of the amount to be paid. The court says the amount was certain at the time of this award. It was a definite sum for a definite term. The MDA provided no contingencies for its termination. So, even though the MDA says this is periodic alimony, which the statute says is alimony in futuro, what the MDA really meant to say, Court of Appeals concludes, is that it was really alimony in solito. So these two lawyers say it's one thing, but what they meant to say was something different. Therefore, it's not modifiable except by agreement, and it does not terminate upon remarriage. So here the trial court was reversed, and husband had to keep paying. The Court of Appeals reminds us that great care should be exercised in crafting decrees, and they say the consequences may depend on the precision of the language used. So this is just a fair warning to everyone. You need to be very precise about the language you're using in your MDA. I'm sure the husband's lawyer here had some very unpleasant conversations that resulted from the way this was drafted. All right, we've got a few miscellaneous issues to look at.
Hey, Cal.
Hey!
I got the report on the end-of-year financials. Good.
Oh, good.
Good. Really great. You killed this quarter.
Okay.
Cal, seriously.
All right. Okay.
Seriously.
Who told you that Emily and I are getting divorced?
Amy heard you crying in the bathroom. We all thought it was cancer.
Oh.
Thank God, man.
Yeah, just my relationship.
Thank God. Oh. Divorce.
I'm so lucky.
You are.
I have to go pick out furniture now.
Okay. You go for it. It could have been cancer, buddy. Everyone, it's just a divorce.
All right. Thanks. Feels good.
This is an eavesdropping case that was filed in federal court. It came out in 2012, but didn't cross my desk until after last year's seminar, so I want to cover it this year. Here, the husband is a wealthy businessman and wife is a lawyer here in Tennessee. She secretly installed spyware on his work computer that ended up logging all of his keystrokes and websites and instant messages and forwarded all of his email to her. Well, not surprisingly, after a year and a half of marriage, they filed for divorce, and in the course of the divorce, she was trying to prove that he had committed adultery based on these emails that showed this adulterous relationship. Well, a husband says these emails are doctored. These are not genuine emails, and so he hires a forensic computer expert who discovers that wife had intercepted these emails and altered them to make them look like husband was having an affair. Well, once those actions were exposed, the divorce settled very quickly. But the case didn't end there because the husband, he's not satisfied with that. He turns around and sues her in federal court for violating the federal and Tennessee wiretap acts, both of which make it an offense to intentionally intercept electronic communications. Now, what we always see in these cases, if you've ever dealt with these issues before, the other party says, well, they knew I was doing that. They consented to either me putting that on there or they gave me their password to their email. That's how I got this stuff. It was all consensual. That same argument came here, and the trial court just rejected it. So now we have a violation of the Wiretap Act, but what are your damages in this scenario? Well, as this case explains, you can prove your actual damages. If you can prove that, you will get your actual damages, but if you can't, there's really no way to quantify that. You can get your statutory damages of $100 a day or $10,000, whichever is greater. If the violations occur for more than 100 days, your damages can be in excess of $10,000. So here, husband couldn't prove that the email interception took place for more than 100 days, so he was just given his $10,000 compensatory award, but the court also awarded punitive damages of $10,000, also ordered wife to pay his substantial attorney's fees and his expert fees for his computer expert, and held that her conduct was extreme and outrageous. This case is important because there's really not a lot, or really almost any, case law in Tennessee on the Tennessee Wiretap Act. So because of that, this federal court had to look to federal law. So this case is important because if you have one of these issues in one of your cases, you will need to read this case. It gives you some guidance on the standards. It gives you guidance particularly on damages. So if you have a Wiretap Act issue, read that case. All right, we've got a couple of prenuptial agreement cases I want to bring to your attention. This first one, husband's a wealthy businessman, wife's in her mid-30s. Prior to the marriage, was a receptionist for an accounting firm and earned $25,000 a year. 4 days before they get married, they execute a prenup that provides that each of them waives their right to alimony if they divorce after 5 years. So if we make it 5 years, no one gets any alimony. Well, they make it 5.5 years, and during that marriage, wife didn't work outside the home, but 1 year after they get married, she's diagnosed with a rare, life-threatening immune disorder. That makes it really a lot easier for her to contract infections and very difficult for her to fight them. And so during this 5.5-year marriage, she had 3 very long hospitalizations as a result of this condition. And by the time that trial rolled around, the medical bills for her treatment totaled $431,000. Wife says, everything in the prenup is valid and enforceable except for this alimony provision, because if that provision is enforced, it's going to render me a public charge. In other words, it's going to make me dependent on public assistance, and therefore it should be thrown out. The trial court says the prenup is valid and enforceable in its entirety, including the alimony provision, and that wife failed to prove that enforcing it would render her a public charge. So, no alimony for wife. She appeals. There's a Tennessee Supreme Court case, the Carey case, that says that an alimony provision in a valid prenuptial agreement will be enforced unless it would render the spouse deprived of alimony a public charge. In other words, reliant on public assistance, welfare, TennCare, food stamps, whatever. So to satisfy the burden of proof, you have to show that within a reasonable period of time after the divorce, it is probable that the deprived spouse will become a public charge if the alimony provision is enforced. So here the court says the proof showed that wife needs ongoing medical treatment to manage her immune disorder. She also needs health insurance that she can't afford, and she needs money to pay her uncovered medical expenses. They conclude that without insurance, her next infection is definitely going to render her bankrupt and reliant on public assistance for her medical needs and survival. So therefore they conclude it's probable that she will need public assistance unless sufficient spousal support is provided. The alimony provision was completely invalidated, and it was then remanded to the trial court to award alimony to wife. So this raises a few questions. One is, what if now, if wife qualifies for subsidized or even free health insurance under the Affordable Care Act, would that constitute a material change in her level of need, justifying a modification? I don't know, but perhaps. But this is also something, if you do prenuptial agreements, you need to advise your clients. You saw in the, well, you're going to see in one here in a second, they provide for a lump sum payment of alimony based on the length of the marriage. When you have extremely wealthy clients, you need to let them know when there's a huge disparity in the earning capacity of the two, or their net worth. You need to let them know about this public charge exception. And one of the ways you might want to get around that, or sort of protect against the risk that you would have an alimony provision invalidated, is to provide for a lump sum payment of some amount, so that you can say within a reasonable time after the divorce, this party's going to get X number of dollars. That offsets this public charge argument. Anyway, just food for thought. It looks like they did something like that here in this other prenuptial case that raises some procedural issues I want you to know about. So we've got a prenup that provides for alimony based on the length of the marriage. If these folks are married between 4 and 5 years, wife's going to receive a lump sum alimony payment of $80,000. But the prenup also said that wife is not entitled to any alimony if she has a sexual affair or commits adultery during the marriage. So husband files for divorce in May when when they separate. In the following February, they execute an MDA that provides that they are agreeing to be bound by the terms of the prenup, and it provides that wife is going to get $80,000 pursuant to the prenuptial agreement. So here, neither party required the other to respond to formal discovery requests. So wife was never forced to swear under oath that she had not engaged in an affair or committed adultery. So everything proceeds smoothly. She gets her $80,000 payment. Well, surprise, surprise, 6.5 months later, wife gives birth to a child. So husband quickly does the math and figures out, hey, wife must have had an affair during the marriage. Even though we were separated, we're still married. So he files for Rule 60 relief, alleges that she fraudulently concealed the affair and the pregnancy from him, and he wants his $80,000 back. Wife admits that she had an affair in December. So they separate in May, affair in December, MDA in February. She had an affair in December and admits that husband did not know about it, but she says this prenup is no longer enforceable because now it's been replaced by the MDA, which was then merged into a final decree, and the MDA says I'm entitled to $80,000. Well, the trial court agreed with wife and denied this relief to husband. It said, what you always hear, both parties are ably represented by the greatest lawyers in the state, and any matters in controversy were merged into the MDA. Well, the Court of Appeals reversed the trial court here in a split decision by 2-1. All 3 judges agreed that the proof was undisputed that wife was not entitled to this $80,000 under the prenup. But the majority said that by executing the MDA that said this payment was made pursuant to the prenup, wife then made the affirmative representation that she was entitled to the alimony under the prenup, even though she knew she was not. So the Court of Appeals directs her to return that $80,000 to husband. In a dissenting opinion, Judge Stafford says, well, look, wife didn't make an affirmative misrepresentation here. Husband could have insisted that wife answer this discovery and admit or deny that she had an affair, but he failed to do so. And he says it's not wife's responsibility to give husband an answer to a question that he hasn't asked. So my message from this case is if your client's payment of money is conditioned upon anything, you need to get a sworn statement from the other party that that condition has been satisfied. Had husband's lawyer done so in this case, he would have surely gained back some of those sleepless nights that he had and maybe some gray hairs that inevitably came from this process. Okay, we have one more case I want you to know about. This is the United States Supreme Court case that deals with same-sex marriage. At issue in this case was the Federal Defense of Marriage Act, also known as DOMA. Section 3 of that law defined marriage and spouse to exclude same-sex partners for the purposes of all federal laws. Well, here we have 2 women in New York that have a same-sex marriage recognized under New York law. It's a valid New York marriage, and that's a photo of the actual couple in this case. Well, when one of them died in 2009, she left her entire estate to her spouse under New York law. But because of DOMA, this valid New York marriage was not recognized for federal tax purposes. So if that marital deduction were allowed under federal law, the surviving spouse would owe no tax at all. But because it was not allowed, pursuant to DOMA, the surviving spouse had to pay $360,000 in federal estate tax. So the surviving spouse sues for a refund, arguing that Section 3 of DOMA is unconstitutional. And the Federal District Court and the Second Circuit Court of Appeals agreed and declared Section 3 of DOMA to be unconstitutional. So it goes to the Supreme Court, and the result is a 5-4 decision authored by Justice Kennedy, so you can imagine it's going to fall out the predictable sides, as you would guess. But the majority opinion notes that historically, regulation of family law has been left up to the states. And so here we've got the federal government stepping on New York's decision to give gay people the right to marry. So here the federal government is seeking to injure the very same people that New York is seeking to protect. and that violates due process and equal protection principles, that New York has a right to govern its family law, and when the federal government wants to step on and take rights away in an area of the law that New York or that the states have historically governed, then it's a violation of the Constitution. But the majority goes on to be very careful to say, look, this case is limited to those couples who have valid same-sex marriages already recognized by the state where they reside. The case is not supposed to be read to confer a universal right of same-sex marriage across the country. Well, we've got dissents from Roberts, Alito, and Scalia, but of course Scalia's dissent gets all the attention because it's the most fun to read and quote in the media. Scalia says that while the majority may say their holding is limited, we all know that the states are surely going to follow suit here, and he specifically says this opinion arms well every challenger to a state law restricting marriage to its traditional definition. Well, as Scalia predicted, actions have now been filed all across the country using Windsor as a basis to challenge the constitutionality of state definitions of marriage as being between one man and one woman. And in fact, Abby Rubenfeld right here in Nashville recently filed the first such action of which I'm aware here in Tennessee. So we'll have to stay tuned on that to see how it shakes out. Hopefully by next year's seminar we'll know the outcome at least. All right, but what about same-sex divorces? What do we do in that case? What guidance might we have? Well, that's another unknown, but we do have the Christensen case from the Wyoming Supreme Court that gives us some guidance perhaps. There we have Wyoming residents who sought to dissolve their valid Canadian same-sex marriage. And so the question was whether Wyoming had jurisdiction over the divorce. Wyoming does not sanction same-sex marriage, so does a Wyoming court have jurisdiction over a divorce? Well, the Wyoming Supreme Court concluded that yes, it does have such jurisdiction. It said, we don't have to recognize a marriage in order to grant a divorce. And they further say there's no law or public policy in Wyoming that closes the door to the courthouse for a Wyoming resident who seeks to dissolve a legal relationship that was created under the laws of another state or of a foreign jurisdiction. So what will Tennessee do when we're faced with this inevitable question? I don't know. I do know that right now this very issue is before the Texas Supreme Court. I would expect maybe they're not going to see it the same way Wyoming does, so we might have a split in the states. There was also, I just read in the paper this week, a case in Mississippi where we had two ladies with a valid California same-sex marriage sought to get divorced in Mississippi, and the trial court said, I don't have jurisdiction, and so they're planning to appeal. So unfortunately, they're not picking the best states to bring these challenges, but we'll just have to see how it shakes out. I think inevitably someone here is going to eventually have someone walk in their office and say, I've got a New York or a California or wherever marriage, and we're Tennessee residents and we want to get divorced. So if that situation presents itself, look to Christensen. That might help you there. Okay, that brings us to the end, so I'm going to now declare all of you officially up to date on Tennessee family law as far as I'm concerned here in the last year. But the easiest way to stay up to date is to read my blog on Tennessee family law. I read these cases, all of them, throughout the year, hopefully so you don't have to, and twice a week I summarize the ones I think are most useful to Tennessee lawyers. You can find it at Hurston Tennessee Family Law or just Google my name. Every single case we discussed today is summarized on the blog, and if you want to find any of the opinions we talked about today, on the blog in the upper right-hand corner there's a little search box. Just type in any of the party names and you'll pull up that post, and the opinions are linked right there. You can also subscribe and get the post sent to you by email whenever I post a case. It can be emailed to you so you can stay up to date. So that's it. Thank you all very much for coming. Thanks for having us here in Nashville, and we hope to see you next year. Thank you.